You're watching Unrendered on IKTV. My guest, the Director of Public Prosecutions, Mr. Colin Williams, and Senator Dr. Linton Lewis, NDP Senator and President of the Bar Association. Colin, when we went on the break, just before Dr. Lewis was suggesting certainly that the humiliation of Frederick was unnecessary, or the perceived humiliation of her was unnecessary. First of all, did this have anything to do with the Office of the Director of Public Prosecution?
Well, it would have to the extent that if somebody is to be, in the case of her charges, they would have emanated from within the Office of the Director of Public Prosecutions. I think that the police who were working along with the Office of the DPP would have had the charges and know about them, right? Now, the thing is, this allegation about intent to embarrass, I don't see where there's this belief that what is so special about her to try to embarrass her. In other words, they have before them, know that that they have the papers for her to be picked up again, right? Just like how she got station bail, she could have been in and out of the police station, consented to proceed with them, an officer of the court. But it is preferable to make a scene, to throw yourself on the floor and to bawl and to parade, rather than simply, okay, you want me? Why, Dr. Lewis is saying, why didn't they say, well, okay, finish your lunch and come afterwards? Similarly, she could have said, well, okay, officers, I'm not going anywhere. I'm just here with my folks. As soon as I finish, I'm going to come to the station.
What was the scene when she was arrested in the first instance? How was that arrest? Was she indeed arrested when she was brought?
Well, I would consider it an arrest. I would consider it an arrest. I wasn't there. As much as my information comes really via the media, right? She was arrested. I would consider it to be an arrest.
But that being the case, couldn't you have issued a summons and brought it?
Proceeding by summons is an alternative procedure.
That could have been done.
It's an alternative procedure to bring in somebody before.
You did it with E.G. Lynch in one of the matters of E.G. Lynch. It could have been done. And in light of the fact that she's an officer of the court, she's a member of parliament, the matter has just been discontinued. In light of the fact that there was no haste at all because there were no extenuating circumstances, any circumstances that can actually influence or compromise the inquiry into the charges that were laid, there was no need for them to have acted in the way they did at that time. And to have that force, a number of police who actually went there, and some of them in a full battle uniform, all of that was unnecessary.
When you say full battle uniform, SSU officers, people, they're dressed in police uniform, somewhere in civilian uniform. But the point I wish to make...
One moment, the fact is this, is that some were just in SSU uniform. And there must have been an intention to humiliate. If there were an intention to humiliate, then there was no need at that time even to try to effect an arrest. It could have been dealt with later on. It could have been dealt with the following day. There was no urgency with respect to that. And one wonders, therefore, if there were no urgency with respect to it, why, therefore, then was it effected in that way? That's a question.
Let's look at the conduct of the I mean, neither of you guys were there, but from what you're hearing, let's look at the conduct of the policemen as they went to rearrest her. How was their mannerism? Was it forceful? Was it, were they going in a cordial manner? What was your feedback on that? How did they conduct themselves? Because that too will tell if really and truly there was an intent to humiliate. So what was the conduct there?
The issue is this. One is not saying that the police who went there intended to humiliate. The whole process is one which gives the impression that there was an intent to humiliate. I had the opportunity to look at the video of what actually transpired. And it was a mixture of firmness and diplomacy and sort of respect by some of the police officers in the way they dealt with the matter and spoke with Ms. Frederick.
All of the police officers behaved professionally. None of them, you can say, were excessive, that they conducted themselves improperly. They, as you correctly said, try to use diplomacy, but being firm or decisive does not amount to force or illegality or impropriety. You know, the police conducted themselves well in the circumstances.
Let's talk about the legality of the whole thing. Because I see the Bar Association, of which you are the president, claiming that the arrest or rearrest of Linton Frederick was illegal.
You know, interestingly, on Wednesday, I made, as president of the Bar, I was interviewed on Cross Country Radio as president of the Bar. Not having the facts as they are stated now with respect to the discontinuation of the matter, I did indicate clearly that there were some gray areas with respect to whether or not it was a dismissal, an acquittal, or whether or not there was an issue of double jeopardy. And I also stated in an interview with the newspaper that there was some humiliation on the part of those who actually were responsible for attempting to and who arrested Linton Frederick at that time. The issue is this, is that under Section 30 of our Criminal Procedure Code, certain offenses can be, certain arrests can be made if certain offenses are committed. To put it simply, if the offense is one that is indictable, the person making the arrest does not need to have
a search warrant.
A warrant.
A warrant to carry the arrest.
The issue there for one is what is or is not indictable in this case. One can recall that the 6 charges that were preferred against Ms. Frederick, I don't think any of them carried a penalty of up to 7 years. And therefore, the impression always was that if they don't carry a penalty of in excess of 7 years,
it's not indictable.
It is not indictable. But up to 7 years, the matter can be tried either way, either summary or indictment. The fact is this, is that I understood subsequently that there were 3 further charges. Of those, I think there was a penalty of in excess of 7 years, if I remember, up to 7 years.
All the 3 additional charges all carry 7 years.
No. So the fact is this, what one needs to try and ascertain at this time, usually an arrest is carried out before a charge is preferred. For the most part, the arrest is carried out for further inquiries or investigations to be conducted. The impression, therefore, then perhaps is that at that time, the charges that were going to be brought against Ms. Frederick may not have been consummated at that time. Because if they were consummated, then there was sufficient time for them to get a warrant or to issue the proceedings through summons without having to go and arrest her in that way. So therefore, the fact is this, is that where illegality or unlawful conduct is concerned, that depends on how the charges will be tried. And under our law, if you have some charges that are indictable and some that are summary, you may wish to have, or all of them can be charged indictably. And therefore, in that case, if they're doing that in that way, then one will say that they did not contravene Section 30 of the Criminal Procedure Code. But then again, is it going to be proceeded in that way?
All wrong. Section 30 provides for the conditions under which a person can be arrested without warrant. Once an officer suspects or believes a person is wanted for an indictable offense, then you are entitled to arrest that person without warrant. That is one of the many conditions.
Clarify for me, what is in fact an indictable?
Indictable offense is a matter that ends up in the High Court before a judge and jury.
Okay.
As opposed to a summary offense, which is before a magistrate, as the original 6 charges were.
Which is a serious
In the 6 original charges, those charges are what we call hybrid. They could either be charged, you could either try them in the magistrate's court, or you can go up to before a judge and jury. There's an election.
Yes.
However, the 3 additional charges that we see are contrary to Section 101, and notwithstanding the fact that the penalty is 7 years, which is within the jurisdiction of the magistrate, right? The Criminal Procedure Code outlines quite clearly offenses which are indeed indictable and which are hybrid, could be tried either way, and so forth. And the section 101 charges fabrication of evidence, which is charged with fabricating, in other words, inventing evidence, is an indictable offense. It is an indictable offense only, regardless to the penalty that is specified.
What did I say that was wrong?
What you're saying is that if there was the intent to proceed either summarily or indictably, it's not how we intend to proceed.
Yeah, but
the fact of the matter is
that is wrong?
Section 101 means that it is an indictable
I know, but
offense
what
only.
is it that I said that was wrong?
It has nothing to do with how you intend to proceed, whether you intend to proceed
No,
summarily or whether you intend to proceed indictably.
you're saying that there's no choice as to how you proceed.
There's no choice as to how you proceed in relation to
the issue is this.
one-on-one.
What I spoke with respect that I said that usually you will arrest someone before you charge them. When you arrest that person, you conduct further inquiries.
You could.
Usually. Good. If you had in your mind, if you knew what those charges were going to be, and you had them already written up, then there was no need for you to go and carry out that sort of
That's a matter of opinion. That's a matter you may choose to proceed one way, but that doesn't make it wrong. The question was whether what makes it illegal. There's nothing illegal. There was nothing illegal. That is the fundamental point.
I'm not saying
stated. There was nothing illegal.
Hold on. I'm clarifying
was there any
gentlemen,
I'm clarifying the point that you made when you said that I'm all wrong. Up till now, I have not heard what I said was wrong. I'm saying to you, on the issue of whether or not these matters, charges will be tried.
I want you, as president of the Bar Association, to distance yourself from the statement that the bar says that it was illegal.
I am going to take a pause here. When we come back and we cool off, we will pick up the matter of whether Dr. Lewis agrees or disagrees that the arrest was illegal. And I think that's what the DPP is asking for you to state or not to state. But let's cool off when we come back from the break. You're watching Unrendered. This is IKTV, channel 45. My guests are Colin Williams, and he's the DPP, and Senator Lewis, also the president of the Bar Association. Of course, we're getting a little heated, or the two gentlemen are getting a little heated. So at the point of departure on this break, we hope that when we come back, temperatures can drop just a little. Stick around.